members, members of the media and the public, secretariat team, dear viewers, ladies and gentlemen, a very good morning to you all. And those who are actually watching this live telecast from the comfort of their home. It's a pleasure to welcome everyone, especially for the viewers that are watching this session. For information, pursuant to the Standing Order 111 of the Standing Orders of Parliament, all committee meetings are to be open to general public. Therefore, please note that this public hearing is open to public and media and is also being aired live on television, in the Parliament channel on Walesi's platform and Parliament's website. For any sensitive information concerning this inquiry that cannot be disclosed in public, this can be provided to the committee either in private or in writing. However, please be advised that pursuant to Standing Order 111, there are only few specific circumstances that allow for non-disclosure of this includes national security matters, third-party confidential information, personal or human resource matters, and deliberation and development of committee's recommendation and report. At the outset, I wish to remind honourable members that our witness that all questions to be asked are to be addressed through the chair. This is a parliamentary inquiry and all information gathered is covered for under the Parliamentary Powers and Privileges Act. In terms of the protocol of this committee hearing, please be advised no usage of mobile phone and all mobile phones to be on silent mode while the meeting is in progress. Now I'd like to actually introduce myself and my members to the submittees. I'm Honorable Elvik Marhat, Chairperson on Justice, Law and Human Rights. Now I'll request Honorable Rohit Sharma if he can actually introduce himself.
Thank you, Chair, and thank you, members. And I'm Honorable Rohit Sharma, Deputy Chair, Justice, Law and Human Rights Committee.
Thank you, Honorable Sharma. Now I'll request Honorable Dr. Salik to introduce himself, please.
I am Honorable Dr. Salik Ram Govind. I am a member of the Justice, Law and Human Rights Committee. Thank you. We welcome Digicel for the submission.
Thank you, honorable members, for introducing yourself to the submittees. Today, the committee will be hearing submission on Cybercrime Bill 2020. As everyone is aware, that this bill was introduced under Standing Order 51 and was referred to Standing Committee on Justice, Law and Human Rights to scrutinize and present its reports in the next Parliament sitting. So far, we have actually received confirmation of 5 virtual submissions. 2 will be done today and 3 will take place tomorrow. And all would be aired live on our Walesi platform. We have received numerous written submissions by our members, which is very good that people are actually showing their interest when it comes to showing interest in the parliamentary work, and especially when it comes to the submission of such bills that are before the committee. So without further delay, we have before us Mr. Peter Ringamoto, the head of legal for the Digicel Pacific Group. And now I invite Mr. Ringamoto to provide the submission from Digicel, and please note that if there are any questions by the members of the committee, they may interject, or we will wait till the end of the presentation to ask our question. Thank you very much. You can now introduce yourself and start your submission. Vinaka.
My thanks indeed to the Standing Committee for Law, Justice and Human Rights, Chair, Deputy Chair and members, as well as the Parliamentary Secretariat and Administration. Digicel very much appreciates this opportunity to present our views on the current wording of the bill. We are keeping our submission to 3 or 4 main points. There are many other points to cover, but we believe these are the most salient points for the purposes of service providers. My name is Peter Ringamoto. I have been working at Digicel for 10 years in the legal division. I am currently head of legal across our 5 Pacific markets, not including PNG. So the other 5 markets that we take care of around the South Pacific. We do hope our submissions are useful, and before diving into the submission proper, we just wish to state that we support the ambit of cybersecurity and protection of national security, and have assisted in discussions on cybersecurity for a number of years now. We have presented the honourable members and the standing committee with a written submission. We also have a somewhat summarized version in a presentation. If you will allow, it may assist in understanding our submissions quicker, and we also wish to provide a brief on the technology used.
Sure, Mr. Ringamoto, you can do that.
Appreciate it indeed, sir. Please confirm if you can see the presentation, sir.
Yes.
Yes, thank you.
The structure of our presentation today, sir, Honorable Chair, is we will begin with a bit of the technological context, then through to the hindrances and how some forms of technology might hinder the effectiveness of the legislation, and then we'll move into our submissions, which had 3 main points.
Okay.
This first, if I may, Honorable Chair, the first slide is a breakdown of internet utilization for Fiji, presented by TFL through a conference paper some years ago, some months ago. But it clearly shows internet usage has increased more than 400% in the last 5 years.
Mr. Ringamoto, if I may actually interrupt, I can still see the introductory slide at this point in time.
Which one, sir?
I can see the only, cover page or the first slide actually. It's not moving.
Apologies, sir. Let me attempt to resolve that technical difficulty. Please let me know if you're able to see the next slide now.
Honorable Chair, if I may.
Yes, Ira.
So I have the slide open in my hand as well.
Appreciate it, sir. So this was the structure which I had spoken through briefly.
Mr. Ringamoto, there is still some technical glitch. What we can do, we can actually ask Ira if he can actually share the slides. Might be
Sure.
his end. Yeah.
No issue. Let me send this to him now.
So,
Yes, Ira.
so I have the slides with me. We don't really have to share the slides, sir, for the purpose of the meeting, so we can just let Mr. Ringamoto read from his submission. I can read the slides from my answer without sharing it. So,
Okay, can you just email the slides to me, Ira, and to the members?
noted, sir.
Okay, thank you. So Ringamoto, you may actually just read it out.
No issue at all, sir. Yeah, appreciate it.
Thank you.
So honorable members and chair, the provisions I wanted to take you through were more along the lines of what you see when you look at the internet technology. And what you generally see is the apps on your phone, you see Windows on your computers, but what you do not see behind that is a network of interconnected computers throughout the South Pacific and the world. Fiji, in particular, is connected by both satellite and international fiber through Fintel.
Yeah.
And that is then transported through fiber and telecommunication towers to operators and then on to customers. Unfortunately, some of the hindrances in the way, and which you will see in my slides also, some of the hindrances that may be found when attempting to implement this legislation is with respect to messaging apps and also VPN and encryption. I go into a bit more detail in the slides, but let me see if I can at least share it in this form. Messaging apps such as WhatsApp, Viber, and others have an end-to-end encryption. What this means is, even if we were able to intercept it locally, without the applicable key to unlock the encryption, you would not be able to see what is behind the message. So even if we were able to pull back the curtain, you would not be able to see beyond the code of a lot of zeros and ones and other data points.
Okay.
This is also the case with other technologies such as VPN, so the virtual private network, which you can use to pretend that you're logging in from the United States if you wanted to watch the United States version of Netflix, for instance.
Okay.
So there are certain software restrictions in place where even if we were able to implement technology locally to look beyond or look into a person's internet connection, it would still be encrypted. Now, moving on to Digicel's submissions proper. In our written submissions, we had said that the definition of service provider was a bit too wide in one aspect, but in the other was too narrow. What we had meant by this was the subsection B, which you might see on your screen at the moment, but if you don't, the particular area of the definition of service provider that we had issue with was that it included an entity that processes or stores computer data. So with that wide definition, quite a few non-service providers, so in the traditional sense, such as banks or even your ICT at the parliamentary complex, might be taken into that definition because you still process or store computer data. So our submission with respect to subsection B was potentially to narrow that aspect or say that it only applies to those service providers that provide services to the public. And therefore, it attaches to companies like ours, Digicel, TFL, and Vodafone, but not inadvertently capturing small-scale private SMEs or the IT divisions of different corporations, government, and NGOs. Our second submission was...
Mr. Indamoto, I'll have to interrupt you again. I'm getting a message from Parliament that the slideshows are causing interference in our live telecast. So unfortunately, we'll have to go out of the slide shows. It's causing some technical glitch in our live broadcast. Yeah.
No issue at all, sir. Appreciate it, Honorable Chair.
Sorry about that.
No issue at all, Honorable Chair. We are more than happy to continue, and you have the slides and our submissions. So I'll speak through them. They might not be as entertaining just listening to myself as opposed to watching those slides also, but please, by all means, if you have a question regarding the slides later, feel free to contact me, and I'd be more than happy to provide further information as the Standing Committee and Honorable Chair may require.
Thank you, Mr. Ira, I'm still waiting for the email. Yes, Mr. Ingamoto, you may continue.
Appreciate it, Honorable Chair. So the first part of our submission was with respect to the definition of service provider, in that it was quite wide in subsection B in order to catch small scale SMEs and the IT divisions of various corporations. So that was too wide. But at the same time, we believe that we as service providers should of course be added. So what we had proposed was to amend the definition to include those who provide services to the public, and thereafter, Honorable Chair, to also include those parties that provide digital platforms, such as social media content communications and content aggregation functions. And the purpose for this, Honorable Chair, was to ensure that those who must provide encryption keys to enable the viewing of data are also covered under this legislation. Honorable Chair, moving on to the second part of our three-part submission. There were some provisions in the legislation which required a judge or magistrate to provide its approval.
Yes.
But there were other provisions such as seizure. Provisions such as seizure allowed required the magistrate or judge, but there were other provisions which did not require it, and our broad submission was that that should be required for various matters. Also, that the threshold for serious offense was quite low in the legislation at 6 months or a fine of $500. Our submission was that the serious offense definition be bolstered to 5 years or more than $10,000.
This is, Mr. Ingamoto, can you tell me which clause you are talking about in the bill itself?
Yes, Honorable Chair. So, for example, if you look into Section 19, which is the expedited preservation, or Section 18 of the current draft bill.
Okay.
So Section 18, a police officer or authorized person may issue a written notice to preserve specific data, and expedited preservation in Section 19. Both the request for both of those do not require a judge or magistrate, but it is only required in section 19, subsection 2, to extend the term of such an application.
Okay, so first 90 days is by the police officer or the
Directly, yes.
So if it has to be more than 90 days, it has to go to the magistrate court or the magistrate.
Yes. Yes. Honorable Chair.
So what are you trying to say is that even the first 90 days should be on the basis that magistrate or judge orders, or what?
Just for consistency's sake, Honorable Chair, our submission was that a judge or magistrate should preside over orders or requirements, and also to note that in the current search warrant provisions in legislation, they have a justice of the peace or a magistrate. In this act for cybercrime, it's a judge or magistrate, but we believe that is a stronger threshold, so we do not have particular issue with that.
Okay. So what about the first 90 days? I'm just trying to get it clear as to where you are coming from.
If there's a need for an order, our general submission is that it should go before a magistrate or judge, at least a magistrate, in order to give effect to the order.
Okay, with regards to this, for example, if we need to actually preserve the data of a stored computer, let's say in the pre-investigation of a police, how would they be able to go to the magistrate first before doing the investigation in order to obtain the data?
The current status quo, even with the present search warrants, Honorable Chairs, it is obtained quite quickly via the police. Again, the mechanism is also through justice of the peace, which may be part of the reason why it's so swift, but search warrants and other warrants and orders are presently quite speedy in expedited. But all we are noting is that there are some requests for orders that require judge or magistrate, and there are others that do not.
So basically what you are trying to say is just that, like, for example, a police officer needs to have a search warrant or something in order to actually enter the office to obtain this data. Not just any officer can walk into a particular office and obtain that data without any search warrant or anything from the high authorities.
Yes, the search and seizure is already under a different power, so that's under section 16, and that requires a judge or magistrate. What all our submission was that there should be consistency amongst the powers in terms of matters which require a magistrate or a judge.
Okay, that provides clarity. Yeah, thank you. We can move on now.
Thank you. The other provision that we have brought to the fore in both our submission and our presentation was the implementation issues with respect to section 22 and 23.
Section 22 and 23. Just let me go to section 22 and 23, please. Okay, yes. Real-time collection of data.
Yes.
Okay.
So 22 and 23 are obligations on service providers, which is fine. Again, with reference to our earlier point about the definition of service provider, it is currently quite wide, but if it was only Digicel, TFL, Vodafone and the OTT providers, for instance. There is a provision there that states that the minister may determine implementation capacity, and that is in subsection 6 of section 23.
Yes.
And in our submission, Honorable Chair, there is already a requirement under the Telecommunications Act of 2008 in section 74 for this assistance. And the original Budapest Convention to which this current bill relates it states that the party shall adopt legislation to compel a service provider within its existing technical capability. So, in short, Honorable Chair, the Budapest Convention to which this relates has a requirement only up to existing technical capability.
Okay.
And the Telecommunications Act allows for a process of discussion before such measures are implemented. We have made submissions as to what we would respectfully believe might be amendments for the purposes of your review in our written submissions. But broadly, those provisions in the current bill are higher than the Budapest Convention requirement, but they are also already captured in the Telecommunications Act, and it is our respectful submission that those requirements of subsection 6, 7, and 8 under section 23, and also section 22, subsection 5, 6, and 7, 5 and 6 be dealt with under the current provisions of the Telecommunications Act through ongoing dialogue. And we especially make those submissions because of the fact that even if a telecommunications operator such as ourselves or TFL or Vodafone were forced to implement technology, without the OTT provider also providing decryption algorithms, we still might not be able to see beyond. We could draw the curtain, but we could not decipher what was at the back of the curtain. So our respectful submission on that point, Honorable Chair, is that this be taken back into the ambits of the Telecommunications Act for further discussion as to how we can do this properly in a way that achieves the goals of the cybercrime bill.
Just confirming, Mr. Ringamoto, for section 23, it's clause 6, 7, and 8.
Yes, Honorable Chair.
And for,
section, yeah.
For section 22, it's 5 and 6.
5 and 6, Honorable Chair. Even 23, I think, I believe subsection 8 is okay. It was really subsection 6 and 7.
Okay.
And Honorable Chair and members of the Standing Committee, that is broadly our submissions. My apologies for not being able to provide our PowerPoint also to assist us through. But to sum up, our view on the definition of service provider is that it is currently too broad and it even captures private SMEs, banks, etc. But we believe that can be amended by a small addition of for those who provide services to the public, and then it will only catch providers such as ourselves. Thereafter, the other area which we have made written submissions on and added into our recommendations were that the OTT providers also be bound by this legislation in the country. And our other two provisions were the requirements for seizure and that discussion around the Budapest Convention requirements in the Telecommunications Act with respect to sections 22 and 23.
Okay, Mr. Bungamoto, just with regards to the service provider, the definition of the service provider, what would be the negative implication if we actually go with the current definition and incorporate all those private entities as you have actually mentioned to be part of the service provider? What implication does it have on the bill?
The only implication there would be subsection B of that provision. So in the definition of service provider, let me just pull up the particular page, Honorable Chair. So it is on page 3 of your bill, oh sorry, numbered page 4, second definition from the bottom. When you go to subsection B, it says any other entity that processes or stores computer data. So when you say processes or stores computer data on behalf of the entity or users. So processes or stores, for example, in your parliamentary complex, your IT division of the Secretariat would have to process or store some of your data. So they are inadvertently caught. So what our submission was is, at the end of this subsection B, to specifically add that this is only for providers of services to the public. So by narrowing it down to providers of services to the public, it only catches providers such as ourselves.
Okay, okay, I do understand from the context that you are coming from, but my question would be, let's say, for example, if I own a private company X, right? And we are actually doing networking between my 10 or 20 branches, but we don't actually store our own data. We have somebody, a company Y, right, which is not a telecommunication company, right, but just a company that is actually providing a seva which we actually hire to store data. So how we are going to capture that if we are actually going to amend that particular provision in the bill?
The key areas that utilize the definition of service provider is mostly around those two sections we talked about, section 22 and section 23. The other provisions of search and seizure and the rest, they can be implemented on any person. So that even includes, how do you say, that includes those types of people that you were talking about who might host externally. But the service provider requirements are strictly with respect to clause 22 and 23, which are about interception and are about traffic records, which is more, how do you say, more in line with what we provide as a service. But it does not stop. It does not stop seizure of that data.
Thank you, Honorable thank you, Mr. Ringamoto, for that clarification, and that is actually well taken on board, and we have noted it down. So once we actually do our committee deliberation, we'll actually have some more deliberation on that particular aspect of the bill. Any questions from your side? Mr. Ringamoto, anything else from your side?
Apologies, Honorable Chair. Nothing further. I believe the only other question I would have would be on process. I recall that the cybercrime bill first came to consultation in 2015 or approximately, and then I know it was a bill in 2019 and then a bill brought back to the standing committee today. What would be the next steps along the journey for this bill?
What will happen now is, since the bill is before the Parliament and the Parliament has passed the bill to the committee, so this is the independent inquiry that the committee is now doing. So once we have collected all the submissions, what we'll do is we'll sit and then review what needs to be done with regards to the bill. And then we'll be actually sending the report in the amended bill, if there is any, back to the Parliament. And then it will be debated on, and if passed, it will be gazetted as an act.
Appreciated indeed, Honorable Chair. I have nothing further, if you have nothing further for me, sir.
Okay. Honorable Sharma and Honorable Govind, if you have any further clarification or queries to be made to Mr. Ringamoto?
No, thank you. I don't have any further comments, Honorable Chair.
Thank you,
Thank you,
Dr.
Chair.
Yes, Honorable Sharma.
Thank you, Chair. At the moment, I do not have. I just would like to see the copy of it, and then we'll come back to it again.
Thank you, Mr. Ringamoto, on behalf of Justice Committee on Justice Human Rights Committee. I'd like to actually thank you for your time and this particular submission. I will request if you can actually email us the presentation that you are actually trying to give us. We'll go through it, and if there's any question, then definitely we'll get back to you with regards to your presentation and your submission. Thank you very much. Thank you, viewers. We'll now take a 10 minutes break before we actually come up with the second submission schedule for today. Thank you, Vinaka.
Appreciate it.